With a great pleasure, I would like to introduce Advocate CA Dr.M.Sathya Kumar Avargal, prominent CA turned lawyer, Indian politician, national spokesperson of Tamilaga Vetri Kalagam, stated by Talabadi Vijay. Advocate Supreme Court, High Courts, Tribunals, District Courts, Magistrates. He is an associate member of Institute of Chartered Accountants of India, ICAI, Institute of Cost Accountants of India, Institute of Company Secretaries of India, Chartered Account Institute of Management Accountants, and the Chartered Institute for Securities and Investment. He also holds master's degree in law, economics, and further earned his PhD in global transfer pricing regime, mentored by the renowned Columbia University professor and SRM University. Mr. Sathya Kumar has been the forefront as a counsel for several landmark cases tackling complex criminal cases that have captured national attention. In the past, he has addressed at overseas branches of ICAI Muscat, ICAI Bahrain, Doha, Uganda, Singapore on several topics. He is a member of International Bar Association, American Bar Association, Revenue Bar Association, and lot many more, ladies and gentlemen. Also member of Chamber of Tax Consultants, Bombay Chartered Accountants Society. In his legal practice, Dr. Satya Kumar has represented both multinational and domestic corporation in complex matters, including direct and indirect taxation. He has significant expertise in tax litigation, transfer pricing, advanced pricing agreements, GST, customs, excise, VAT, and service tax. His role also extended to provide NRI taxation, pre-litigation strategies, dispute resolution, closure of matters under double taxation, and legal advisory relating to taxations. He has authored professional books on GST Companies Act 2013 and also Law for Professionals. Very interestingly, he's also acted in a Tamil movie titled National Leader in Stardom role of Netaji Subhash Chandra Bose, which has reached masses and recommended also for the National Award. Well, ladies and gentlemen, with a huge and thunderous round of applause, let me welcome forward Advocate CA Dr. M. Sathya Kumar Avargal. நல்ல ஒரு பலமான கைத்தட்டலுடன் சார் அவர்களை அன்புடன் அழைப்போம். तालियों के साथ हार्दिक स्वागत करेंगे.
It's a great pleasure to be here in banknbfc.com program. I first of all extend my warm wishes to Praveen Chakravarti being present here in the August gathering, and he gave a wonderful insight, and he is present in the capacity of the professional. So am I. So the views I express, the points I make, it's only from the perspective of my legal profession, not from any other dimension. Here we are in this important gathering. Before 10 years or 15 years, if you go back and check the credit access to the micro, small and medium enterprises, I precisely wanted to touch upon that and just wanted to touch upon various risk aspects of this channel partner and NBFCs that need to be known by all of you, to ensure that you all avoid risk and also mitigate risk if it may come. If you see the profile of India as such, 94% of employment opportunities created by micro, small and medium enterprises. We are in Coimbatore, Tiruchengodu, Sangagiri, Namakkal, Tirupur, Erode. All these places I have visited and I have interacted with the entrepreneurs. 94% of the employment opportunities. It may be formal, it may be informal. But if you see the credit taxes, only 4% comes from the formal economy to the formal channel to MSME. Even today it is minimum. We are here to ensure we give credit access to the micro, small and medium enterprises. The law is an enabler for this. Of course, there are challenges in law. Lot more reforms need to be done. If you see, 73% of the credit in the Indian economy continues to flow through NBFC. Go to a place like Karur. Go to a place like Rajkot in Gujarat. Go to Morbi. The NBFCs are the pillars of the MSME. And this NBFC regulations have become tougher and tougher and tougher. Why? because many have violated a liberalized regime. Many have done scams in the liberalized regime. Today, deposit accepting has been regulated. In 2019, parliamentary law was passed by the union government called Banning of Unregulated Deposit Scheme 2019. We all should understand what is meant by BUDS Act. What is exactly the government wanted to rectify or trying to resolve? Over a period of time, in the name of financial companies and chit funds and all those things, Ponzi schemes, unregulated deposit schemes started happening, and only when the default happens, the prosecution happens. But in 2019, accepting an unregulated deposit itself is now a crime under the Banning of Unregulated Deposit Scheme. Of course, under the Companies Act 2013, you have regulation preventing a company from taking deposits. This with respect to unregulated entities, banning of unregulated deposit scheme. It does not apply to just company. It applies to LLP, it applies to sole proprietorship, it applies to partnership as well. And this is an international regime. Nothing India brings new. You tell me a law, I'll tell you where is it already there. It will be there either in the Europe, or it will be there in the US, or it will be from common law jurisdiction or some civil law jurisdiction. So considering all these things, a very important law the audience should take away is about the banning of unregulated deposit scheme. Then comes your India's digital credit vision. It's good to have great ambitions of digital credit system, but we also have Digital Personal Data Protection Act 2023 in operation. Data fiduciary angle has started coming in. You can't handle the customer data as we handle as of now. There's a phased manner in which you have to strengthen your data systems, data security, and any breach will amount to huge penalty as provided in the act. About 250 crores is what they say in the act. So how are they going to implement it? How are they going to prosecute it? It's a challenge. I don't deny that. Of course, we lawyers are there to defend. That's different. That should not give you a confidence. That should ensure that there's a system in place to implement these laws. So, Digital Personal Data Protection Act, along with your digital credit vision, has to be empowered. We all know the government of India. I don't give credit to any party. The government of India, as per our Constitution of India, Article 12, parties may come, parties may go. Government has to go on forever. There's a state as per article. We are under the state as per Article 12. Let's have that maturity. Government has developed national strategy for financial inclusion. And this vision is for about 5 years, 2025 to 2030. Now we have AI coming in, algorithms coming in. Everything is boosted through algorithm. The fight is now with algorithm. AI coming in. So it's going to be a challenge. And these challenges, the Supreme Court in the month of November, they have alarmed about digital arrest. Crores of rupees. It amounts to 11,000 crores, 12,000 crore. And digitization is a boon, and it's also a bane. Think about a retired person at 60 losing 5 crores, 2 crores, 3 crores. Where will he go and earn? So there is a challenge with respect to digital credit. People are afraid today. We educated also, certain times we become victim. And you go and complain to a cybercrime, nothing happens. So you have to system in place to show your authentication. Developing a platform is not important. How do you bring security systems around it is important, because you are in a very important sector, risk sector. You are a risk sector. So accordingly, to mitigate risk and avoid risk, ensure that you counter every digital issue that is foreseen in the industry. We expect India's digital lending. It's a huge opportunity. Take it from me. Mr. Arun has taken up this great initiative. I just saw his vision. banknbfc.com, aggregating all the aggregators and lenders. That is your LSPs and digital platforms together. This market is going to be about $1.3 trillion. $1.3 trillion in 2030. We are gearing up. India is the market. So these platforms and channel partners has to ensure we follow Reserve Bank of India's Digital Lending Directions 2025. It is a direction, and these directions provide for three important aspects. One is digitally signed key fact statement. I'm speaking you. That's called, speaking to all of you, digitally signed key fact statement. That is KFS. That's the key point for the channel partners. Second, direct disposal of loan proceeds to the borrower's bank account and no intermediary routing. Very important. If you take money in the intermediate routing, there is always a risk that it may attract Budzac. It may attract Budzac. And if a case is filed in the Budzac, the twin brother is the Enforcement Directorate. Prevention of Money Laundering Act will anyway get attracted. So you have to ensure you have system in place, you have CRM in place, you have digital systems in place, security systems in place, and that has to be audited every year. So it's just not fun to start a digital platform, but you should ensure the systems are placed in respect to channel partnership. Last but not the least, which I wanted to highlight to all of you, is about AML provisions that are prevailing. AML provisions, anti-money laundering provisions. Reserve Bank of India has issued a master circular. Bankers know about it. The SFT transactions are notified. Every banker is a reporting entity to the Financial Intelligence Unit. Every banker is a reporting entity to the Financial Intelligence Unit. Based on May 3, 2024 notification, even chartered accountants have become reporting entity, deemed to be a reporting entity. So the systems are getting strengthened. Reporting aspects are becoming very elaborative now. Considering it, what is the AML provisions core requirement? A, customer due diligence. Customer comes, you have to know who is he, what business he does. Go to ChatGPT, research and do research about the directors and check about their background. Do a kindly ensure you do a risk assessment process before you accept them as a customer. You don't know where the source of money has come. If that money comes into your system, then there could be a debit freeze. There could be a bank freeze that could happen, which will affect other customers of you. So ensure you maintain you have a system for customer due diligence. Enhance your due diligence. And transaction monitoring is important. Sample checking is important. Have both statutory auditor as well as your internal auditor. Also your Companies Act requirement, that is 143 under section 143 subsection 12. You have internal financial control requirements. There's a COSO framework, there's a COBIT framework, and if you, of course, for banks, Basel II norms and all those norms apply, but still you extract the best practices to your channel partnership as well. Even though you may not take money, still strengthening it is very important. And then comes, if you find any suspicious transaction, you have a right to report, you have an obligation to report to FIU, that is Financial Intelligence Unit, IND. There's a website for it. You can go and check. Maintain record. Next question comes, how many years should I maintain record? Suggested and required number of years is 5 years records you should mandatorily maintain. Beyond that, if you maintain, well and good for all the regulation, but ensure that you maintain. Ensure that the digital lending does not bypass any of these AML provisions. This is what I wanted to convey, because any violation which attracts prosecution and any regulation that you bypass may be fatal and it may affect your going concern. So this is my humble request to, because it is really, really enthusiastic to innovate, to work on taking a risk, but it is also important, you should ensure that you mitigate the risk, avoid the risk with proper reporting, due diligence and customer records, and maintaining proper system in place with your chartered accountant who is accountable for your work. This is what I wanted to convey in this session. There are multiple other issues which definitely we need to have a dialogue and discussion on the regulation perspective, on the law perspective, but this platform, I just wanted to convey this information. Thank you so much for this wonderful opportunity.